Good morning, good afternoon, good evening around the world. My name is Doug Brunke with Global Chamber, and if there's nothing else that you take away from this presentation today, remember that Polsinelli is a great place to come to no matter what industry you're involved with, no matter what part of the world you're part of. You can get information you need around trade through their experts, and this is really, I think, an unprecedented opportunity today. 13 experts from Polsinelli from all over the United States, 7 different cities, and they cover the entire world. So you're going to hear information about agribusiness and technology and manufacturing and every kind of a business that you might be involved with, and you're going to hear about trade activity that's going on everywhere in the world. There's never been a time when trade deals were changing as rapidly as they have been, and so we're very lucky to kick our program off with Melissa Proctor. Melissa's going to give an overview of what's happening overall around the world, and then we're going to cut down into some industries, we're going to cut into some areas, and you'll be able to, in these next 2 hours, be an expert around international trade. And if you have additional questions, not only be able to ask them here, but also follow up. Follow up with me, Doug Brunke, doug@globalchamber.org. Follow up with any of the speakers, and we will connect you in after the event so that you can get additional questions that you have answered. I'd like to now introduce our first speaker, Melissa Proctor.
Thank you, Doug. Thank you to the Global Chamber for giving us this opportunity. We're very happy that you all are joining us from all around the world and all around the U.S. as well. Everybody's got such a busy schedule. I'm going to kick this off this morning talking about kind of the key developments that we've been seeing on the international trade front. As you all know, as you've been monitoring the situation like we have, we've seen a flurry of activities and developments on the trade front just since the transition from the Obama to the Trump administrations just this past January. Let's talk about some of the key issues that we've seen and that we've been monitoring for our clients. Cesar, you can go ahead and advance to the next slide. Thank you very much. All right, this is a timeline that we've put together of some of the key international trade developments going back to January of this year. Let's start with the Trans-Pacific Partnership Agreement. Shortly after the inauguration in January, we all know that the U.S. formally withdrew from the TPP. Now, the TPP was supposed to have been the largest regional free trade and investment agreement that has ever been negotiated, and it included not only the United States, but Canada, Mexico, and 9 other countries in the Asia-Pacific region. What's important to keep in mind is that it did not include China. Now, the TPP would have eliminated duties on imports of more than 18,000 goods into the signatory countries, and many of those goods are subject to currently pretty high duty rates. We now know that the other TPP signatory countries appear to be continuing on with the ratification of the agreement and implementing that agreement under their own laws. They're going to proceed without the United States. But what's really interesting to me is that we saw many of the TPP provisions included in the initial leaked U.S. Trade Representative's letter that outlined the United States' specific objectives for the renegotiation of the NAFTA. Kind of ironic. We then saw at the beginning of the year many new executive orders being issued by President Trump. The first one we call colloquially the 2-for-1 executive order. It's entitled the Reducing Regulation and Controlling Regulatory Costs. And it basically provides that for every new regulation introduced by a U.S. federal agency, 2 old ones have to be repealed. Now, there was an exemption made for those regulations that relate to U.S. national security, such as the State Department's International Traffic in Arms Regulations, or the ITAR. However, there have been a lot of discussions as to whether or not that same national security carve-out applies to the U.S. Commerce Department's Export Administration Regulations, or the EAR. And it appears that that carve-out does not apply to the EAR. So what does that mean? Well, we have been in the midst of a very rigorous export control reform process since 2009, where both the State Department and the Commerce Department have been revising both the ITAR and the EAR, harmonizing definitions, transferring jurisdiction of items from the ITAR over to the Commerce Department. If the EAR is not subject to that 2-for-1 carve-out for national security reasons, that means that the Commerce Department has to comply with the 2-for-1 rule. which means essentially that whenever we have a new development come on the export control front, it's going to be very difficult for both state and commerce to issue their simultaneous amendments to the ITAR and the EAR. The Commerce Department is going to be slowed down to a great deal because of the 2-for-1 rule. So that's something that companies, especially in the export world, and those companies that are subject to both the ITAR and the EAR really need to keep in mind. Going on down the timeline, we see that there were 2 separate executive orders that were issued on March 31st. Both deal with comprehensive assessments or reviews by the federal government. The first EO was called the Omnibus Report on Significant Trade Deficits. And here, the Trump administration requested a formal review, a formal assessment of all of the U.S. trade deficits with our trading partners and an identification of the root causes for those deficits. The second EO is entitled Addressing Trade Agreement Violations and Abuses. And that also called for a review of potential trade agreement violations by our trading partners and also violations of the GATT by our WTO partners as well. And both of those reviews are currently ongoing at this time. Now, later in the program, I know Greg Jacobs in DC is going to be talking more about the executive order that was issued, the Buy American, Hire American EO that happened in April. Just to give you a flavor for that, the Buy American, Hire American rule really covers both a crackdown on the H-1B guest worker visa program, which apparently there have been alleged to have been many rampant abuses with the use of that visa program, while the Buy American side is aimed at compliance with federal domestic procurement requirements. And I know that Greg is going to go into a lot more detail about that in just a minute. All right, let's turn now to the NAFTA. That really is the focus of really what we're focusing on for our clients, especially here in Phoenix, Arizona. On May 18th, the U.S. Trade Representative submitted formal notification to Congress of the administration's intent to begin renegotiation and modernization of the NAFTA with Canada and Mexico. The USTR then requested public comments with regard to how the NAFTA should be modernized. They also held a public hearing at the International Trade Commission in Washington, D.C. in late June. The USTR actually received more than 12,000 written responses and heard the testimony of over almost 150 witnesses representing many industry sectors. Now, the majority of the comments and the majority of the opinions that were provided in that hearing testimony really strongly supported the NAFTA. The industry largely urged that these negotiations should not jeopardize in any way existing market access gains that U.S. companies have had as a result of the NAFTA going back to 1994 when the agreement was first entered into force. And the industry also urged the USTR to really move forward with a key negotiation principle of do no harm. That was actually the words of the USTR Lighthizer, do no harm. Don't jeopardize existing supply chains and companies, businesses, and operations that really depend on the North American Free Trade Agreement. A couple weeks later, July 17th, we saw that the USTR published a summary of its specific objectives for the renegotiation of the NAFTA. Now, there had been a few months earlier, before Lighthizer was formally installed as the USTR, a leaked letter that provided a lot of detail about what the USTR, the acting USTR specific objectives were at this time. On July 17th, we saw another list that was issued. That was much more vague, very broad. It was not as detailed as that original leaked letter. The July 17th negotiation objectives reflect many, but not all, of the items that were on the wish list of the industry. And of course, these specific objectives were developed, and that were supposed to have been developed, from the public comments that were received, from the testimony that was given at that ITC hearing, and also from consultations with Congress and other industry sectors. What's important to note is that there was no specific mention at all in the specific objectives of the do no harm principle, which was kind of disappointing to say the least. However, the USTR did say that it would strive to maintain the existing duty-free market access for trade and goods for U.S. companies. All right, let's talk about the border adjustment tax just briefly, and here's some good news for a change. On July 27th, House Speaker Paul Ryan announced that the previously proposed border adjustment tax, or what we call the BAT, will not be included in the upcoming House tax reform effort, which is a good thing. Under a BAT scenario, both foreign and domestically produced products would be taxed, And the cost associated with any imported goods or imported raw materials would no longer be able to be deducted by corporations under the new corporate tax system. At the same time, the VAT would not be imposed at all on export sales. So there was a benefit if the VAT was only to apply to exporters. But if you're an importer, such as those industries that are largely dependent on imports, such as footwear, textile and apparel, the automotive industry, computer, high techs, where their supply chains are really driven by the imports of raw materials, parts, and components, the VAT could have been disastrous for them. There are only murky details, really vague details that were ever released about the VAT and what the Congress's plan was for the VAT. But it was speculated that it could have increased the cost of imported goods in the United States by almost 20%. Again, there was a strong lobbying effort by those industries that are heavily dependent on imports to strike down the VAT. And largely due to their voicing of their opinions, we believe that the VAT was effectively shelved. Okay, let's turn to the NAFTA, the renegotiation and the modernization of the NAFTA. So we know that the renegotiation of the NAFTA will entail 7 separate rounds, which will be held in 3-week intervals. Okay, and it's a very fast, ambitious schedule because we want to ensure that the process is completely concluded before Mexico's 2018 presidential election is in full swing. Now, the first round of talks took place between August 16th and the 20th in D.C. Presentations were made by the U.S., Mexico, and Canada on the scope of the NAFTA. The 3 countries agreed on the need to update the NAFTA rules, and the negotiating groups began their work. Now, the second round took place in Mexico City, September 1st to the 5th. The word on the street from what we're hearing is that the 3 countries really have a long way to go. They had very little to show from their efforts during the round 2. There were some points of agreement that we've heard. For example, consolidation of the language for a number of proposals on energy and the environment, cross-border investments, telecom, and digital trade. There were some points of contention, primarily over wages in Mexico. Apparently, the negotiators discussed a report about Mexican auto workers earning 1/9 of the wages earned by their counterparts in Canada and Mexico. And Canada's biggest private sector union actually came out and said publicly that the NAFTA should be tossed if Mexico cannot agree to better labor standards for its own workers. We've heard that there are some in the Mexican political and corporate realms that are really pushing back on the demands to bring Mexican wages in line with those of the U.S. and Canada. So that's an issue that really needs to be watched. We know that Mexico and Canada agree on leaving the Chapter 19 dispute resolution chapter in the NAFTA. And under Chapter 19, any kind of dispute that arises under the NAFTA has to be handled by private NAFTA panel arbitration process instead of referring the matter to the court as we do for all of our other trade disputes. The United States is really pushing to eliminate that from the NAFTA altogether. We've heard that some of the comprehensive energy reforms that were proposed by Mexico back in 2014 are being considered for inclusion in the NAFTA, and that Canada is also really pushing hard for greater access to professional visas, both in the U.S. and Mexico. Rounds 3 and 4 will take place in Canada and the United States in late September and October. All right, Cesar, you can go ahead and transfer one more slide. Thank you. We don't have time to go through the slide other than I really wanted to mention one key thing. This is all the U.S. embargoes and economic sanctions developments. And you can see there's also been a lot of flurry of development in this realm as well. What I want you to take away from this today, and if you have questions about any of these programs, please let us know. But on August the 2nd, Congress and the President signed into law the Countering America's Adversaries Through Sanctions Act, or CAATSA. It went into effect on August 2nd, and it targets Russia, Iran, and North Korea. Now, we've had embargoes and economic sanctions on these countries for many, many years. In fact, North Korea sanctions goes all the way back to the 1950s. But CAATSA is, for the first time, codifying the sanctions that are on these countries. It expands those sanctions, and it also limits the president's ability to unilaterally lift them. So CAATSA is something to take a look at and keep tabs on as we move forward. With respect to North Korea in particular, OFAC Office of Foreign Assets Control, which is part of the Department of the Treasury, recently added 16 Russian companies and Chinese companies to the specially designated nationals list. This is a list of companies and individuals that U.S. companies and persons are prohibited from dealing without prior U.S. government authorization. They were added to the SDN list because of their dealings with North Korea. So we will likely see more SDNs added to the list and perhaps even more expansive sanctions on these countries for which we've already had sanctions on. I'm now going to bring up Mike Patterson, who's going to talk about NAFTA, Mexico, Latin America, and he's even going to talk a little bit about the border adjustment tax. Thank you.
Awesome. Thank you, Melissa. And by the way, her practice every day, heavy Asia, Canada, Latin America, UK and Europe, and even some African work as well, African nation work as well. Trade. Any question on anything, Melissa's expert, as well as the others who are to come as well too. You got me on there? Buenos dias. I lived 10 years Latin America in 3 firms in Mexico City and a year in Costa Rica as well. And so if you have, I'm going to talk in a minute what's hot in Latin America, distribution to Latin America, nearshore manufacturing in Latin America. I wanted to give a little perspective. We're 850 lawyers in 23 cities, but we're also part of a multi-law network that covers 300 cities. And every day, the people on this call are talking to 2, 3, 4 of our lawyers in our network, getting local help along with us to make sure you're covered with your needs. And if you have a need anywhere, we can probably find you the help. In fact, I know we can. Let's keep in perspective some of the NAFTA negotiations. I want to give some other things happening outside of the box. Canada, let's remember, I've got my little tag here, Arizona in the middle and Mexico and Canada, because I really always want to remind us, Canada's our biggest foreign direct investment partner for most of the states in the United States, many of them. Mexico is our biggest customer for 33 of the states. It is here in our state and in many of those who are part of this multi-office presentation today. For example, who would have thunk it, but Illinois, heavy trade relationship with Mexico. Colorado, Denver, one of the largest cross-border proponents, Gil Cisneros out of Denver, has been huge. So Mexico, big customer for all of our states. Of course, California office is on here as well, our San Francisco folks. What big things are happening to have on your radar? July 1st of this coming year, less than 12 months away, a Mexican 6-year election. Every 6 years, presidents are not reelected, and they get 1 term. So we have 3 not officially announced candidates, but AMLO, A-M-L-O, on the left, your left here, okay. Andrés Manuel López Obrador, and then on the right, Margarita Zavala, probably from the PAN, and then Osorio Chong, maybe from the PRI. There's many other names being batted around, but AMLO is pretty for sure as a leading candidate. It looks like the wild card race in the Major League Baseball. If you were to take him as 0, she's several points behind, and Osorio Chong in the polls maybe 7, 8 points behind. It's still early, but many people have said if the election were held today, probably AMLO, and a very different president possibly in Mexico. However, I still believe, and most of the lawyers that I'm working with believe, that there is a strong business community in Mexico, a virtual wave of the last 20 years, bringing Mexico from what it is currently in the 13 to 15 world largest economies to maybe by 2015 major publications in London, New York, and other places around the globe are predicting that Mexico will be number 5, the number 5 world economy by 2050. What would that do? What would that change? Would that by its own inertia, raise wages in Mexico? Would that by its own, as a consequence, probably change a lot of our immigration issues so that they become moot with Mexico? So in our best interest is preserving, I think, helping them get to that point, because they're our biggest, we do a lot of trade with them. They're our biggest customer from the U.S. And think about content, comparative content. When you buy from China, how much U.S. stuff is in what you buy when you buy a trinket from China or a machine or something? 4%. Okay, when you buy from Canada, 25%. When you buy from Mexico, 40% U.S. content. We buy 40% our own stuff on average when we buy something from Mexico, machinery, etc. We make things together in North America. An average auto part before it goes into a plant, into the Nissan plant in Aguascalientes, or into a Chrysler plant in Saltillo, or into the Ford plant in Hermosillo, or before those parts go into those plants, they have crossed the border back and forth with the U.S. on average 6 to 8 times. Value added there, value added here, value added there, value added here. That's why Melissa says how devastating the estimate would be if a border adjustment tax was passed, how devastating that could have been for particularly the automotive industry, but also aerospace and others that are burgeoning between our three nations, not just Mexico, but also Canada and the automotive, for example, and other industries as well. So what's hot? Distribution is hot to Latin America, but you have to be careful on some things. Nearshore manufacturing. So I don't, you may be able, you used to, the wages, by some calculations are now, there's not much of a wage differential with China versus Mexico. And so, and also I have to deal with getting a ship over and getting it in a harbor that's in the middle of a hurricane, or a shutdown in Long Beach as well. Those are some of the issues that manufacturers are looking at. Should I consider Mexico or Latin America for my call center or manufacturing instead of China? And so, but what do I need to be concerned about? And also I want to mention, I had a panel recently, and one of them is in the room today, Hector Plasencia from BRH2, and we've talked to these executives and asked, are these supporting high wage jobs in the United States when you do something nearshore? Absolutely. In other words, it enables them to remain competitive. Pardon my commercial today, but I do feel passionately about a lot of this. What are the key issues? Structure. Make sure you got a good structure in the U.S. to support your Latin American structure, or your UK structure, or your Canadian structure, and I work on that every day. Tax presence and labor presence. Need to think about, is the way I'm going in with just a manufacturer's rep, or with a distributor, or setting up a subsidiary in that country because of licensing issues or otherwise, do I need a subsidiary? Would I want to protect myself better by having one, or should I go without? Licensing issues in my particular vertical that I'm trying to do. Import, export, and trade. And Melissa, are you leaving money on the table because you've misclassified something, or you could classify it better to get a lower lower treatment coming into the U.S.? Own your own registrations. This is a huge issue for a half dozen of my clients in the last 5 years, where even though the agreement is very clear that when I terminate my distributor who had the registrations, those registrations come back to me. But the distributor says, not so fast. I'd like $4.5 million. I don't care what the contract says. And by the way, you'll be out of business for 2 years while you're trying to get your own registration, your new one. Really? Okay. And then now the leverage is there to ask for it. So there are intermediaries that can hold your registrations, things like that. That's what I look at. Make sure you get paid. There's ways with letters of credit or credit insurance, Ex-Im Bank credit insurance protection. Be profitable. Trade finance. There are ways to do trade finance to make you more profitable as well. intellectual property control and licensing. What's going to happen to my intellectual property? And a lot of people say, oh, you got to do arbitration internationally. That's the only way, and malpractice if you don't. Really, what if I need to carve out to be able to protect my intellectual property, or to have an audit right if I have a cross border where I'm getting paid versus how many of these we produce? Do I need to carve out some of that? How do I repatriate money back into the United States? There are ways, different ways that you can get the money back across the border. Dividends, royalties, interest on loans, consulting between the mothership and the daughter, and charging consulting services for when they send you down X per hour. And each one of those under our treaties has a different withholding and tax rate per each country that you go into. So you should do some planning up front on how I'm going to get it back. And then transfer pricing. Each government tax authority wants to get their fair share of this cross-border transaction between mother and daughter. Okay, so you need to make sure that you're doing it in the right way so that those tax authorities don't say gotcha at the end. And then one last comment I would make is all this discussion that we're seeing isn't necessarily what it seems. And if you don't mind my using your example, Hector, one of our friends here is Injection Plastics in Hermosillo, Mexico, and they had a contract awarded for 18 plastic parts to go into a major international automotive manufacturer that you would know of that was battered around during our cycle and our election cycle and political cycle here in the U.S. But very quietly, that international automotive manufacturer just shifted one of their automotive lines, not all of them, but one of them, out of Hermosillo to China. So they lost 18 plastic parts that were going into that. And I would just observe for you, sometimes when we are badgering these things around and we're making a lot of statements about, how's this going to help us or hurt us, the loss and the move of that one car back to China, I want to observe, that didn't come back to Detroit. We didn't get those jobs back in Detroit. The real risk is us as a region losing that manufacturing competitively to Asia. And so that's the real competitive, and we at our firm love clients who are doing business in Asia too. I'm not negative on that. But what I'm trying to say is when we make these decisions and we want to clamp down on trade, we need to think there may be some effects that are not the ones that we thought we were going and targeting after. And I'm going to finish early. Thank you.
Okay. This is Doug, and I'm in Phoenix, and we're going to take some questions because we do have a little bit of time. And so I'll ask the audience here if you have questions, and also ask the audience around the world. And you can type them into the chat area, and Cesar will be monitoring that. So one of my questions, and please, audience, if you have some, let me know what those are. The question I have is, for these companies, you've given, I think, a really outstanding broad view in terms of some really kind of good and some potentially really dangerous things happening from the standpoint of them. What should they be doing at this point? Should they be looking at operations in Asia? Should they be supporting people who are lobbying to support their business here in North America? Is that a case-by-case situation? What would you say would be the answer to some of that? If you guys want to come up here, and you should be on camera, not me, because you guys are the stars. I'm just a lowly moderator. So if you guys would stand here, and I'll ask the questions and also watch the room. Do you have any?
One comment I didn't mention is Mexico has more free trade agreements than anyone else in the world, and they have a great relationship with Asia. And I do know several clients who've mentioned, if we get real restrictive in the U.S., we may just shift everything to Mexico and let them work with China directly on. And that was a total kind of a surprise to me that there's not this restrictive trade view with our neighbors, either in Canada or in Mexico, and there may be many unintended results out of this, and that's a thought.
I think for companies, you've got to look at a lot of different issues. You've got to look at, number one, you don't want to be sourcing from just one country. If you're only sourcing from China, you are going to run into some issues with trade remedies, anti-dumping duty orders that are and investigations that are already starting, countervailing duty investigations that are starting for subsidies, and allegations that China and a variety of industries for a variety of products are dumping on the U.S. market. That's going to affect your sourcing. It's going to raise your cost in the U.S. because you have additional duties to be paid. Look at countries that have free trade agreements or for which the U.S. has a unilateral special trade program in place, such as Generalized System of Preferences. There's the Africa Growth and Opportunity Act. We have a lot of, like I said, free trade agreements with over 20 countries. That eliminates duties for products coming into the U.S., finished goods as well as raw materials. But if you're an exporter, it also makes your goods more attractive, less costly when they're being marketed to the partner country. So there's some, you want to look at cost, you want to look at savings, you want to look at risk. And you want to look at risks from, number one, what's going to happen with the NAFTA. I think really from my perspective, it's do your homework. It's stay on top of all of these developments. Every time a new proposal comes out, every time there's a new news blip, read it, just digest it and see how it could possibly affect your supply chain and your operations, because you may need to make some pretty nimble decisions pretty quickly, depending on whether or not you have a 300% duty rate added to the goods that you've been bringing in at a previously 15% duty rate because of an anti-dumping duty order. Or if something happens with the NAFTA, perhaps a change in the rules of origin, you're going to have to look at your sourcing. You're going to have to re-qualify all of your products to make sure it satisfies the new rules. So it really is staying on top of all of these developments, educate yourself, and really get involved in the process. There are always public comments that are being solicited by the government, hearings that are held. 12,000 public comments were issued for the NAFTA. I mean, that's amazing. And that's how companies can protect themselves and can make their voices heard. And Congress hears it, and they are worried about midterm elections coming up. So make sure that you are part of the process so that you're protecting your supply chain, your operations, your customer base, and your company going forward.
I know I watch the Polsinelli International blog, as one of my data sources for information. There is a lot of information out there. What do you guys use to keep up? And what should a typical executive at a company think about in terms of how they keep up?
Well, we're watching the Global Chamber blog every day.
Exactly.
You saw that coming. No, really, your members have been pretty prolific as well, and Melissa has a number of trade blogs she's following. I'm following a bunch of Latin American ones as well, including a Latin lawyer publication that's very prolific as well. I would also make another comment. Latin America, if you're wanting to think Latin America, it's not just Mexico. Major markets are Colombia, particularly Peru and Chile, and of course Argentina and Brazil. But Costa Rica and Central America, very hot, and the Caribbean's heating up as well.
Yeah, very good. Thank you very much. We have a question. David, could you come up? Sure. We have a question from the audience here in Phoenix, and then we'll move on to Washington, D.C. as our next speaker. So our questioner is David Farka.
So one of the big bones of contention in the NAFTA negotiations, especially on the U.S. side, has been trade deficits. Can you talk a little bit about that and what's your view on what the deficits really should be, how they should be considered or not?
Sure. You need to jump in on that?
Yeah, go ahead.
Okay. I think there's been so many studies on what is the root cause of the trade deficits. And I think what we're hearing a lot from the Trump administration, that it's all to blame, lay it at the foot of all the free trade agreements. I don't think that's the case. I think there have been many other studies that have been done that says, trade deficits could be one result of a free trade agreement, but there's also production, capacity. There's also modernization. There were trade deficits back in the Reagan era, long before NAFTA was even a forethought. So I think you have to consider trade deficits to try to figure out, are there abuses going on? Is something not being enforced correctly? And address that and tweak that. I don't think that you can blame the trade deficit solely on our entering into free trade agreements, because we know since 1994, we really have a multi-regional bloc now with Canada, U.S., and Mexico, and it has bolstered the economy, not only for Arizona, where we are right now, but for all three countries. I think what we said that 1 in 4 jobs here in Arizona are tied directly or indirectly to the NAFTA. So there's a lot of benefits that came out. I think a lot of people did get left behind, but I don't think you can blame the trade deficit solely on free trade.
And I would add, in terms of just it's a very complex issue, including tax policy. If our tax policy is such that we're encouraging our U.S.-based multinationals to be offshore, then that really warps the figures on what the trade deficits look like if they're maintaining their trade out of if they're keeping their profits and the flow of money and economic activities going elsewhere, but really the home base of that entity has a real strong connection to the U.S.
I have a quick question, Lisa.
Okay, so we'll take that question here offline. But Ricardo Gallego, thank you very much for your question, but we're going to have to go to Washington. Thank you, Melissa and Mike, for your insights. And remember, any of our speakers can be contacted directly off of the Polsinelli website, or send me an email and we'll make sure that you're connected to either Melissa, Michael, or our next speaker, Greg Jacobs. Over the next several speakers, we're going to be talking about new global data privacy regulations. We're going to be talking about FinTech. We're going to be talking about aerospace and defense. We're going to be talking about pharma, medical devices, global mergers and acquisitions. And our next speaker, Greg Jacobs, all the way across the U.S. in Washington, D.C., will be talking about country of origin and Buy American executive order. Greg, thank you for joining us in Washington, D.C. Could you enlighten us around what's going on with this executive order and in this area?
I'll be glad to. Thank you very much, Doug, for that introduction. It's great to be with you all today from Washington. As Doug said, my name is Greg Jacobs. I'm the chair of Polsinelli's government contracts practice. We have a team of government contracts lawyers that are based here in Washington, D.C., working on all issues related to government contracts, including the one I'm going to talk about today, which is the issue of country of origin requirements in government contracts, and in particular, some changes that may be coming in that area as a result of some policy priorities from the new Trump administration. So just to start, go to next slide, please. So country of origin requirements fit into the category of what we in government contracts call socioeconomic requirements. So when the government buys goods and services, its primary purpose is to obtain the good or service that it's buying. But as many of you know, particularly those who've been involved in government contracts in the past, the government will also attach additional and oftentimes ancillary requirements to those contracts in order to further some policy goal. So we see, for example, affirmative action requirements. We see new requirements related to human trafficking policies. And one of the main areas we see is in country of origin, where the government has made a decision in its policymaking function that it wants to a certain extent, promote U.S. industry over industry outside the U.S. When it acquires goods and services by contract. And so we'll talk about the main ways that it does that, starting with the current state of country of origin laws. And really, for our purposes, there are two main laws and sets of regulations that we worry about. This is a very complicated area. There are a number of smaller statutes that have impacts. There are statutes that pertain to specific countries like Israel. We don't have time today to go into all of those side issues. We're just going to focus on the two major points. And the first is the Buy American Act. You sometimes hear people say Buy America Act. That's actually something else that pertains particularly to DOT acquisitions, but the Buy American Act is the main government-wide country of origin law. And it applies to procurements for goods, for products between $2,500 and $191,000. And for construction contracts, for materials for construction contracts, it applies up to about 7.3 million and change. And what the Buy American Act, or the BAA, does is it requires the delivery of domestic end products. And that requires a little bit of unpacking. What does domestic end products mean? So for non-manufactured goods, so for things that are natural resources, for example, they have to be mined or produced in the U.S. So that's fairly straightforward. There's no foreign element to that. It's something that is made here or mined here, extracted here. For manufactured goods, that's where it gets a bit more complicated, because as we all know, the supply chain for manufactured goods these days, for the reasons that, for example, Mike and Melissa talked about, often involves work in and components from several different countries. So in order for a manufactured good to meet the definition of a domestic end product under the BAA, it must meet two requirements. The first is that it must be manufactured in the U.S. So the actual manufacturing, the final manufacturing process must take place in the U.S. And the second is that at least 50% of the component cost must be U.S. origin components. So look at the total manufactured item, you break down the component cost, you do an analysis to make sure that at least 50% is U.S. And that second part does not apply to items that are commercial off the shelf. So consumer goods and other items that the government purchases that are commercial off the shelf, they're sold in the same fashion to commercial customers. They don't need to meet the component test, just the manufactured in the U.S. test. And what the BAA requires is that offerers, when the BAA applies, when they submit their offer to the government, there's a Buy American Act certificate that requires you to identify those items that are not domestic end items. And how BAA is implemented is basically a evaluation preference for domestic items. So an offerer, if the low offerer on a procurement, the lowest price offerer is offering foreign end items, there's actually a price evaluation factor that is added to those items to increase the price. So for large businesses, that's 6%. For small businesses, it's a 12% factor. And actually, it doesn't say on the slide, but for Department of Defense procurements, it's a 50% evaluation factor. So you can imagine that puts non-domestic products at a fairly significant disadvantage from a price perspective if the Buy American Act applies. The second major source of country of origin requirements under government contracts is the Trade Agreements Act. The Trade Agreements Act essentially starts where the BAA leaves off. So it applies to procurements that are valued at $191,000 or higher, or for construction projects that are valued at $7.3 million and change or higher. And the TAA is a little bit different from the BAA in that it requires it's broader in what it allows. It doesn't solely require the delivery of domestic products. It requires the delivery of end items that are either domestic or designated country. And what does that mean? Well, first of all, the TAA applies a different test to determine whether a product is a domestic or a designated country product. It applies the substantial transformation test. So it doesn't look at the value of components. It looks at whether the item it was substantially transformed. So essentially it became changed from being its separate components into a different and new item in a particular country. And that analysis is completely separate and different from a component test. What do we mean when we say designated country end products? Well, that's pretty broad, actually. The designated countries, which are listed, all of them in the Trade Agreements Act clause of the Federal Acquisition Regulation, include the World Trade Organization countries, plus any other country with which the United States has a trade agreement that would encompass this type of government procurement, plus certain developing countries. So there's a long list of developing countries that are included. So there's actually a pretty substantial list of countries which have products that are permitted for delivery under the TAA. The most important thing to note is which countries are excluded. And there are really four that become very important here. China, India, Malaysia, and Vietnam are not designated countries for Trade Agreements Act purposes. And where the Trade Agreements Act really becomes an issue for a lot of countries is under the Federal Supply Schedule. So anyone who's familiar with the Federal Supply Schedules, or FSS, knows that that's where the government purchases a lot of its routine products and services. So things like software, things like office supplies and consumer goods that the government purchases in very large quantities, it doesn't want to have to put out a whole RFP for every time. So it will go to preset pricing on the Federal Supply Schedule. And a lot of providers of consumer goods sell, and commercial goods sell to the government on the FSS. Well, the Trade Agreements Act, the TAA, applies to the FSS, which essentially means that the government is prohibited from purchasing through the FSS unless there's a waiver. Products that are made in China, products that are made in India, in Malaysia, in Vietnam. This can be a real issue for some companies that have less visibility into their supply chain. Probably the best example are office supply companies, which several years ago actually were ended up in False Claims Act litigation and ended up in paying substantial settlements to the government because they were delivering Chinese-made office supplies to the government under the Federal Supply Schedule. So that's an issue that companies who have FSS contracts tend to be very aware of, very concerned about. So that's the current state, and it's worth noting. It's worth noting that the one of the major issues to look for on both of these are the presence of waivers, the availability of waivers, which agency heads can make. Next slide, please. So where are we now? Well, we know that President Trump was elected stating a priority to keep jobs here, keep manufacturing here, keep purchasing here. In April of 2017, the White House released an executive order called the Buy American and Hire American Executive Order. A lot of people were expecting something like that. I can tell you that this as an initial policy document really did not change the state of the current law. It expressed a policy that agencies should scrupulously monitor, enforce, and comply with domestic preference laws and minimize the use of waivers. But all that really means is it's a policy of the White House that agencies should use fewer waivers for BAA and TAA requirements. What it does require is that agencies provide a report within 150 days of its issuance, which puts us actually at the end of this week, so this Friday, regarding their enforcement of the existing TAA and the existing country of origin laws and their use of waivers. And then after that, within 220 days of the issuance of the order, OMB and the U.S. Trade Representative submit recommendations to the White House on how to strengthen domestic preference laws. So no change in the law yet, but we can see it coming based on the stated policy preferences of the administration and based on the information that's being gathered in anticipation of some potential changes to the law. What will that look like? It seems as though that the availability of waivers will likely be cut down. There's a lot of criticism that agencies overuse waivers, particularly the so-called public interest waiver, as a way to get around particularly Buy American requirements. So that's one part of it. And then the other likely part of it is reporting. So we're likely to see more visibility, more public information that's made available so the American people and politicians are able to understand exactly how agencies are or are not following country of origin preferences when doing purchasing. I believe that we are out of time. I actually have one more slide that I was planning to cover on current legislative options. It's up there. It tracks very much with what we've been saying. What's interesting about this is it's a piece of legislation that's been around since 2015 from Connecticut Senator Chris Murphy. The legislation would make changes to the BAA. It would bump up the component test to 60%. It would limit the use of certain exceptions. It's being considered. It's the kind of thing that's likely to see more visibility and consideration as the results from the agencies on the president's executive order come back at this month and then into the coming months. What's interesting, of course, is that how bipartisan this issue can be. President Trump and Senator Murphy are on very different ends of the ideological spectrum, but both see value in changing the existing rules to require more use of more purchase of domestic products and also limit the agency's ability to get around those requirements. Thank you.
Greg, there's an applause here in Phoenix and perhaps all over the world. People's hearts are beating a little faster and they've got a better understanding of this. As you mentioned, we're a little bit out of time. So Ricardo, your question, could you email that to me, that you had, and anybody else that has a question portion, please email that in either to info@globalchamber.org or check the Polsinelli site for Washington, D.C. Another, we'll get your question to Greg. Obviously, not only very competent and very knowledgeable, but one of the really cool things about working with Polsinelli, my own experience, is they're all professional. And he's already noticing the time, and so many times that doesn't happen in the professional world. And I really appreciate that, Greg, not only the information, but the timeliness. We're going to go up, take a short Amtrak ride up to New York City right now with Jarno Vanto. He's going to be talking about the impact of new global data privacy regulations. Jarno, welcome. Thank you for speaking today, and we look forward to becoming more educated about this topic. Thank you.
Well, good morning, good afternoon, everyone, wherever you're sitting in this country. My name is Yarnavant. I'm the co-chair of Polsinelli's Privacy and Data Security Practice Group, and this morning talking about the impact of the new global data privacy regulations. I do not have slides. Hopefully that's acceptable to everyone. There's a lot of ground to cover in this short period of time. Hopefully we'll be able to touch upon at least the most pertinent points for companies that are operating cross borders. Given that the overall context here today is NAFTA, one thing I can say to begin here today is that the United States is currently the only NAFTA country that does not have a comprehensive federal level privacy and data security regulation. Both Canada and Mexico do have a comprehensive federal level privacy and data protection statute in place, and overall globally, if we look at the United States among the global players in the economy, the U.S. is soon becoming the only country in the world that does not have a comprehensive federal level statute on the collection, disclosure, and processing of personally identifiable information or personal data, however you want to call it. And if we look at Latin America has been a topic here today. Latin America, almost all of the countries there have a data protection law in the books, and in that sense, the Latin American countries are following the global trend. But where regulation is becoming a major issue for any country, any business doing business across borders, is those companies that are doing business with the European Union. So if you have customers, users, employees, subsidiaries in the European Union, 28 member states of the European Union, you should be right now focusing on two things. First, that's of more of an immediate concern right now is the EU-US privacy shield. Many US-based companies have certified themselves compliant with the EU-US privacy shield to transfer, meaning make accessible online, for example, EU origin personal data of their employees, customers, etc. to the United States. Right now, this September of 2017, the European Union is undergoing its first review of the Privacy Shield. The results of that review should be out by the end of the month. And what the European Union is looking at right now in terms of how the Privacy Shield actually operates in practice is focusing on two areas. First, the current administration has failed to appoint many of the appointees that were agreed to between the European Union and the Department of Commerce in connection with the Privacy Shield. For example, one of the key appointees was supposed to be an ombudsman in charge of all issues relating to privacy and EU origin personal data. That ombudsman has not been appointed. And the Privacy Shield mechanism also created what is called the Privacy and Civil Liberties Oversight Board. None of the members have yet been appointed until last week when Trump finally nominated a new chair for the Privacy and Civil Liberties Oversight Board. That appointment is likely to raise some eyebrows with Europeans, given that that person is Adam Klein, who has been advocating warrantless searches of data originating from the U.S. and Europe. And so we're going to look at the European Union is going to take a comprehensive look at the Privacy Shield, and the results will be out by the end of this month. But most likely, the Privacy Shield will stay in place. Otherwise, many U.S. businesses would not be able to transfer any of their EU original personal data from the EU to the United States. But it will likely undergo revisions, making some of those requirements to transfer data from the EU to the U.S. stricter than they are right now. but I would keep an eye on the results of that review and see where the tables will turn around the Privacy Shield. But there are indications that Europe would like to put in place a stricter regime for EU-US data transfers. So I would definitely keep an eye on those developments if you operate or have a subsidiary customers, users in Europe. And then one other thing about the Privacy Shield is that it replaced what was called safe harbor. Many companies on this call probably were certified for safe harbor. An interesting fact about the Privacy Shield versus safe harbor, that over 3,000 companies that were in safe harbor have not certified for the Privacy Shield. So that raises a question of what these companies are. There are obviously very many reasons in play, but there raises a question of what these companies are doing with their EU-US data transfers right now. One other major development I'm sure everyone on this call has heard about is called the General Data Protection Regulation. The General Data Protection Regulation enters into force in May 2018, May 25 to be exact, and it will replace all of the currently existing European Union member state data protection laws. It will comprehensively regulate all processing of personal data originating from the European Union. And given that Europe wants to assert its regulatory powers globally, it'll have a very broad scope of application that will impact many U.S. companies, even some companies that wouldn't obviously seem like they would be within the scope of the application. But essentially, if you have any users of your website or your mobile app or you're tracking consumer behavior online of European consumers, or if you have employees in Europe, or if you have subsidiaries in Europe, if you have patients in Europe, if you have clinical trials in Europe, you're going to be captured by the General Data Protection Regulation. And what that entails is that you should, in order to ensure that you're compliant by May 2018, you should start looking at comprehensively looking at the data flows of your company, making sure that if you have any of those EU origin personal data points coming to the US, that you comply with the GDPR. Polsinelli helpfully provides a comprehensive GDPR checklist for gap identification that enables your company to perform a self-assessment and identify those compliance gaps so that you can move closer toward compliance, because the fines for non-compliance, while I believe that they will not be the first on the list of remedies of the regulators in Europe, they will be significant. So we're looking at 4% of the global revenue of a company, or 20 million, whichever is higher. But the UK Information Commissioner's Office, which is one of the member state regulators, indicated last month that these fines will not be the first on the list of remedies that they're going to go after for companies. Keep in mind that the cost and the reputational risk of any fines will be significant. That's it. Hopefully I was able to cover some of the pertinent issues on global data privacy laws. Thank you.
Jarno, very good. Thank you very much. Bob, do you have a question?
Yes. A quick question with the data breach through Equifax. What do they have to prevent that from happening there?
Okay. I don't know if you heard that question, the data breach with Equifax.
Yes, I did.
Oh, perfect.
Yes, thank you. Thank you for the question. The only thing that the laws can really do is to make the cost of not building in comprehensive data security mechanisms into all company-specific processes so prohibitive that companies just can't afford not to secure the data. But really it comes down to technical security around these technologies, and if the companies are not taking that seriously, even companies that are processing the data of all American citizens basically with a credit history, how those companies then suffer is through lawsuits and investor lawsuits and consumer lawsuits. But right now, they're, in terms of the law, it really comes down to technical security and how seriously companies take it.
Thank you, Jarno. We're going to have to move on. There are a couple questions actually that we received, but we'll forward those to you. And of course, if you have additional questions, anyone that's viewing around the world, send those in and we'll have those handled. Before we leave the East Coast, I do want to mention that with Greg Jacobs there in Washington, D.C., Aaron Felix, and we have someone entering our door here. Welcome.
Sorry, I'm too sorry.
Thanks for joining us. I think people are starting to hear about the seminar, and they're coming in from all over the place. So Aaron Felix, coming in from Washington, D.C., is a resource on country of origin and Buy American Order. And then also Chris Ward in my old hometown of Wilmington, Delaware, right between New York and Washington. So Polsinelli has got at least 3 offices there on the East Coast. So now we're going to switch all the way across the country, almost up into the high reaches of the Rocky Mountains. Richard Levin is going to be talking about FinTech, and having seen this presentation, you are going to be hopefully not overwhelmed, but you're going to walk away with a lot better understanding of this hot area. Richard.
Thank you. Rat poison, bigger than the internet. The blockchain could change everything. That's what FinTech is about. And when we talk about international trade, we're talking not just about the technology behind something known as Bitcoin, but we're talking about how that technology is going to impact shipping, logistics, healthcare, pharmaceuticals, insurance, aerospace, and the automotive industries, just to name a few. I'm Rick Levin. I'm the chair of the FinTech and Regulation practice at Polsinelli. We are a practice that brings together lawyers from across the firm. We bring together lawyers from corporate, securities, tax, regulatory, white collar, public policy, employment, and IP. And we work with firms that are both very large, some of the largest technology firms, some of the largest financial services firms, and trading firms. And then we also work with some of the very early stage firms. So what is FinTech? FinTech is a combination of the technology that has been commonly used for thousands of years. Cryptography. You can go back and look at the Mesopotamians, okay, and you'll find that cryptography has been used for thousands of years. But we're taking cryptography, we're combining with computer science, and then we're combining with a variety of industries that I just mentioned. And we're going to take information off of hosted ledgers that are maintained by corporations around the world and put that data onto the cloud. So if you could go to the next slide, please, since I don't have control. Examples of FinTech. We have blockchain technology, and there's not just one blockchain, there's lots of blockchains. Many of you have heard of the Bitcoin blockchain, but there's the Ethereum blockchain, there's the Hyperledger blockchain, which is developed by IBM, Microsoft Azure. Then we talk about other types of FinTech, crowdfunding, platforms like Rocket Hub, Indiegogo, Kickstarter, digital asset trading platforms. So if you hear about people trading Bitcoin or Ethereum or initial coin offerings, they're traded through some of these digital asset trading platforms. Peer-to-peer lending. 10 years ago, nobody would have thought that you could go on the internet and get a loan. Now we have Prosper, we have Lending Club, we have SoFi, we have other platforms where you can go and get loans to pay for a home, to repay debt, to consolidate credit card debt, or other types of financing. My wife gets mad at me as a FinTech guy. When Prosper and Lending Club came out, I took out loans. And it took about a week to do it. Small loans, but I wanted to see what was involved. And then recently, Goldman Sachs launched a platform named after one of the founders of Goldman, Marcus Goldman. The platform is called Markets. It took 5 minutes to get a loan from Goldman Sachs. Hey, I should have mentioned, who am I and why am I here? I'm the son of a computer scientist who skipped math in 5th grade to program computers against high school students. Unfortunately, skipping math at that age is not a good thing. it puts you on the path to being a lawyer and not being a tech billionaire. So today I'm here because I have an interest in new technologies and also the financial services industry. In 1999, 3 years out of law school, I quit my firm in Denver and I went into a tech startup. I joined 2 other entrepreneurs, all of us in our late 20s, who said computerized trading is the future. I told some of the attendees here the story, but I'll repeat it for the bigger audience. We went to the New York Stock Exchange at 28 years old and said, this will all be done by computer. You should buy our firm, invest in our firm, or partner with us. We met with the management, including the CEO, in a dining room, people wearing white gloves, serving tea and coffee. The paint was flaking on the walls, lots of mahogany. And they insulted us. They said we looked like we were 12. You know, we would like to think we looked like we were 16 or maybe 14. At a certain point, we were young but not stupid. We realized that they weren't going to invest in us. So one of my colleagues said, you know, you're a battleship. You're big, you're old, you're gray. You can't turn on a dime like we can. The management was highly offended. Did you just call the exchange a battleship? And my friend said, yes, a battleship. And then my other friend said, no, no, no. They're not a battleship. But someday when this is all done by computer, the New York Stock Exchange trading floor is going to make the best damn discotheque in Manhattan. At that point, the profanity flew. Large security guards came in, and we were thrown out on the corner of Broad and Wall Street. But we sold our company to Citibank, and then I moved to New York and represented electronic trading firms from 2000 through 2011. One of my famous stints was I was supposed to be the general counsel of a joint venture of Lehman Brothers and the London Stock Exchange. I arrived in London the day Lehman Brothers failed. My job vanished. Came back to the States, worked for Deutsche Bank on the business side. So when I talk about this stuff, I've lived it most of my career, not in a law firm, but in corporations working with many people like you, trying to figure out how this technology is going to change our world. Other things that we're going to be talking about, peer-to-peer payment technologies, Chase Pay, Starbucks Pay, Apple Pay, Ant Pay. We're going to talk about lending platforms, other ones like Cabbage, Rocket Mortgage, robotic investment advisors. People may not know that the algorithms that have been driving trading for almost 2 decades now are coming into investment advice. And if you sign up with an investment advisor, you will have the ability to say, rather than having a human manage my money, I want an algorithm to do it, to maximize returns. We also can then talk about securities, new types of cash securities platforms that are developing to help facilitate the sale of unregistered securities that are not listed on exchanges. And last, we also can talk about IBM Watson and Ross, forms of artificial intelligence. And I have to tell you, we law firms are also in the crosshairs of the advance of technology. Ross is a version that will deploy in law firms. One of the best examples of new FinTech is a technology called blockchain. Blockchain was started originally as part of a digital currency called Bitcoin, which has gotten a lot of media attention. Time magazine actually put up a cover that showed the famous founder of Bitcoin, Satoshi Nakamoto. Nobody knows who Satoshi Nakamoto is. Nobody knows if he or she is a single person or a group of people. But what they did was they said, we're going to create a digital currency that has a finite supply and that will be mined. Now, when they say mining, it's the worst word they ever picked. They should have called it solving complex math problems and getting a reward. By calling it mining, they've attracted the attention of regulators around the world who think it's a commodity. But Bitcoin has grown, and now you see a whole flurry of at least 1,000 other digital currencies that have been created, and it's spread. It's spread also into an area now called initial coin offerings, where companies are saying, I'm going to do an offering of digital tokens to raise capital. Now, what many of these young tech entrepreneurs don't realize is that act is comparable to selling securities without a registration with the SEC, without an exemption, and it puts them in the crosshairs of a lawsuit. I jokingly tell my clients, I'm like a good golf caddy. You hire me at the beginning, I keep you out of trouble. I'll do my best to keep you out of the sand traps. You hire me at the 9th hole, after your scorecard looks like garbage, I'm not responsible. I'll try to get you off the course in a reasonable period of time. So as we look at blockchain technology, what we're looking at is the technology behind Bitcoin and how that technology is going to transform it. Now, we have a video that I wanted to show, but I think, unfortunately, the video that was given to the conference organizers is too long. It's 57 minutes. But several years ago, on Fox News, Warren Buffett, Bill Gates, and Charlie Munger, Buffett's business partner, were asked about Bitcoin. Now, Charlie Munger, brilliant man, says, it's rat poison. I don't get it. I don't understand it. It doesn't make sense to me. Bill Gates, a techno entrepreneur who's built one of the most powerful companies in the world, he's now one of the wealthiest people in the world based on his intellect and his understanding of computer science, says it's a techno tour de force. It could be bigger than the internet, but of course governments are going to have a role. Now, what I love about the video is that then she asked Warren Buffett, and Buffett says, well, these two guys are smarter than me. I'm going to wait for them to figure it out, which is the quintessential Buffettism. But it does put you in a position where you can see the spectrum of people's views on digital currency, the most commonly recognized being Bitcoin, and the technology behind it, blockchain. Charlie Munger, I joke, is like the guy riding around in an 1880s horse and buggy holding a 1980s giant cell phone. Bill Gates is a techno visionary. He's one of the people who sees the potential in new technologies, a voracious reader. He understands the potential for blockchain. And then there's Buffett. And Buffett's the ultimate pragmatist, saying, well, I don't know if it's going to be a success, but I'm going to wait till people figure it out, and then he'll probably make big investments in the space at the appropriate time. Could we go to the next slide, please? So this slide presents blockchain. So what is blockchain? Blockchain technology in its truest form is a mechanism for recording data on a distributed ledger. So rather than a ledger hosted by an insurance company or a bank or a shipping company or a healthcare company or a financial services company, the data exists in the cloud. And people have the ability to write data to the cloud and to view data on the cloud. Now, the way the chain works is that if I am the originator of a transaction, that data, Rick Levin or whatever identifier I use, is recorded to the chain. Then if I sell to Michael Patterson some amount of whatever we're talking about, a product, the chain will record that I sold that product or a portion of it to Michael Patterson. And then going down the list to my partners and friends, if I sold them Bitcoin, other digital currencies, or a product that any product is on the blockchain, you would be able to track it. Now, what is truly unique about the blockchain, again, is it's distributed, is not hosted on a central server. If we look at what's happened with fairly high-profile attacks involving computer servers hosted by corporations, be they retail companies, be they credit companies, credit card companies, shipping companies, even payment systems like SWIFT, you'll see that those are all hosted systems that were penetrated by external forces using a security breach. The beauty of the blockchain is it functions almost like neighborhood watch. Everybody on the chain is monitoring everybody else who has authority to view the data on that chain. There's a wonderful video I can't show you, but it's from IBM. And after the financial crisis, Congress said that companies need to track what are known as conflict minerals. So if you're buying diamonds, you cannot buy what are called blood diamonds, or diamonds that are mined in order to fund wars in various parts of the world. And what IBM pointed out is in blockchain technology, their version, Hyperledger, you could record the diamond from the point it is mined to the shipping, to the processing, to the shipping again, to where it then winds up in store. And that chain will show you a visual image, a digital image of the diamond. It'll record the serial number of the diamond, and it will include pretty much all the information about the life of that diamond. So if you are Helzberg or Zales or somebody who purchases diamonds to sell to the public, you will be able to say in good faith that you know that that diamond is not a blood diamond, that it is not a conflict mineral. Now, the technology is being used by companies like Walmart. Walmart has decided to use IBM's platform to track shipments of pork from China to the United States. So again, just like with the diamond example, you will be able to track the pork, little piggies on the farm in China being loaded on a truck, then being sent to a processing facility, then being loaded on another truck, then being loaded on a ship, that ship arriving in the port of Los Angeles, unloading it onto a truck, a refrigerated truck, and then arriving at the Walmart in your store. Now, why is this a big deal? People don't realize, one, the amount of adulterated or tampered with food products in the world. We have periodic outbreaks of listeria, of E. coli, of other foodborne illnesses that are caused by not being able to track the food that is being shipped around the world. So blockchain is going to enable us to do that. One of the largest shippers in the world, Maersk, is now doing it. People don't realize these giant cargo containers floating around the oceans periodically tip their products off into those oceans, and they don't know what was in the cargo container. So Maersk is now saying, well, we will be able to track every cargo container on our ship, when it arrived, when it was offloaded, what were the contents, and if a cargo container does not arrive in the port, we will know all of the contents because it is recorded on blockchain. Could we go to the next slide, please? Firms focusing on FinTech. This is just one segment. If you look at this list, we have traditional banks and we have stock exchanges, some of the biggest players in the world. This list is out of date. There's a consortium of 93 banks and exchanges called R3 that are focusing on how to use blockchain in their business. Could you go to the next slide, please? Next slide, please. Okay. This is a list of the FinTech 50 firms from just KPMG. The first one on the list is Ant Financial. Ant Financial started off as Alibaba Pay, like PayPal. It is a private company that is valued, according to estimates, $65 billion. It'll probably be one of the biggest IPOs in the next 12 to 24 months. But these are the hot FinTech 50 companies. You'll see some names that you recognize. SoFi, you may recognize companies like Funding Circle or On Deck. Next slide, please. Here are the 20 FinTech companies to watch. You'll see companies like Ripple, who has its own blockchain. You'll see Abaca, BioCatch. These are companies that, again, according to American Banker, are going to be shaping the future. Next slide, please. The views of FinTech are divergent. As I pointed out, Charlie Munger, Warren Buffett, Bill Gates are the perfect example. You're going to run into a divergence of ideas, but you do see that people like Peter Thiel, who was at Palantir and before that at Facebook, helping Facebook get off the ground, Fred Wilson and Union Square Ventures, these are people that do believe in FinTech. Next slide, please. Next slide. There's more slides that I want to show you, but we're out of time. The thing I will leave you with is if you are going into FinTech or going into blockchain, you have to remember that it is a regulated area. In the United States alone, the Securities Exchange Commission, the Commodity Futures Trading Commission, the Internal Revenue Service, the United States Treasury, the the Fair Trade Commission, state regulators are also looking, and the Office of the Comptroller of the Currency, are all looking at FinTech. They all want to regulate it. So if you're going to go into FinTech, whether it's for shipping, for international trade, for finance, or any other purpose, you need to make sure that you speak with lawyers, whether it's our firm or another firm. You want to make sure that you're doing it in a way that you don't inadvertently engage in activities that could be deemed banking, money payment processing, lending, or commodity trading. So we're happy to help. Any questions for this group? Yes?
I don't know if they can hear me, but maybe you can repeat the question.
Sure.
So China made a major decision last week on cryptocurrency, and I was just wondering, what is the impact of that? In particular, the FinTech companies from China, there's a number of them up there, including some from Hong Kong. What will happen now with this new decision, and how does that affect the development and the interests of states and financial systems?
So the question, just to repeat it for the audience in other offices, was that the Chinese government recently issued an order with respect to digital currencies, including Bitcoin.
Richard, we could hear the question.
Oh, you good? Okay, good. So the answer to that is regulators around the world, the United States, Europe, Hong Kong, Canada, Singapore, are all looking at how digital currencies or tokens or initial coin offerings are offered to the public, and they're all basically saying the same thing, that it could be a security. And they're saying if you're going to do it, you have to comply with the law of the jurisdiction in which the people live who are buying those tokens or digital currencies. So China, there has been a fairly pronounced reaction to what China did, but people have to remember China is the largest market in the world for Bitcoin and other digital currencies. I suspect what we will see is companies trying to comply with the laws, whether it's treating it as a security or a commodity and selling them under that model. Other questions?
Thank you, Richard. I think we're going to have to move on, but a quick question.
Okay.
There are certainly companies that are involved with FinTech, but every company will be involved with FinTech opportunities, right? So companies that are thinking about when should I jump in, when should I do anything with Bitcoin or other programs like that. Do you also advise companies that are not FinTech around how to navigate the area?
We do. We actually work with healthcare firms, shipping firms, automotive, aerospace. We'll work with everybody who's trying to figure out how the technology that is behind many of these digital assets called blockchain could impact your industry. We're happy to work with you on that.
Fantastic. So Richard is in Denver. So thank you very much. I mean, to the whole idea of getting 15 or 20 minutes and talking about FinTech probably was, is a crazy idea, but you know that Richard's available as you have questions, whether you're in that industry or you're just looking to be more successful with your business. Thank you, Richard. And we do also have a couple questions for you that we'll follow up with you on. We're going to shift now over to Chicago. And we've got Tom Gemmell waiting. He's going to be talking about recent aerospace and defense developments and their impact on U.S. companies. Tom, are you there in Chicago, and is it snowing yet?
That's right. There you go. Okay, yeah, I'm here. Do you hear me?
Yes, we can.
Okay, good. Ready to go.
Fantastic.
Let's start off with the first slide. Thank you very much for having us, and I'll be talking about some of the areas in aerospace and defense in particular, how they're affecting our current situation. Okay, so next slide, please. We're talking about 4 different areas. No, one before that, please. Okay, 4 different areas as it relates to aerospace and defense today: the economic outlook, merger and acquisition activity, intellectual property, and key technologies. Touching upon each of those, essentially we've got a boon in aerospace and defense in terms of the economic outlook. Over $700 billion in revenue and over $70 billion in profit, or $700 billion in revenue, $70 billion in profit, were achieved by aerospace and defense companies in 2016. It's only expected to go higher as the years go on. 2017 is going to be another banner year, both in defense as well as in the commercial space, and also 2018. Next slide, please. In the commercial space, we're talking about a strong, essentially strong aspect of promotion is being pushed by the global passenger increase due to lower fuel costs in particular, and that's expected to continue as it goes forward, not only in 2017 but also in 2018, according to Deloitte's Aerospace and Defense Outlook. Next slide, please. Over 20% overall growth in operating earnings, 1.7% increase in revenue, and over 12.7% in operating profits. The continued aircraft production rates are expected to increase going forward. In fact, in terms of the Boeing and Aerospace or Airbus, the 2 primary OEMs, we're talking about backlogs of over 5,000 to 6,000 aircraft already in the books right now. They've increased their aircraft production rates from 40 aircraft per month to about 50 aircraft per month. Boeing primarily in the 737 space, and the Airbus with their A320s. Those are expected to increase going forward. Excluding regional aircraft, the demand for new aircraft is expected to be over 35,000 aircraft for the next 2 decades. And again, primarily driven by the increase in the increase in passenger demand. Next, please. On the supply chain side, we're primarily looking at consolidation among the manufacturers of electronics, interiors, and aircraft components, and aircraft manufacturing components below that. And in terms of the overall pressure on the supply chain, we're talking about competitive pricing decreasing the amount of margin for those companies as a result of the lower airfares. Next, please. On the defense side, we're seeing the same type of boon in terms of aerospace and defense economic outlook, primarily driven by the global security threats that are out there and the release of some of the sequestrations due to on the budgets, the military budgets, and major regional powers such as Japan and India, and also countries in the Middle East that are asking for more money and are asking for more aircraft and more weapon systems to be produced for them so they can meet those security threats. Next, please. Looking on the U.S. side, 2.3% increase in defense subsector revenue, 3.2 billion increase in defense spending, according to the National Defense Authorization Act that was input by Obama, President Obama last year. Trump has upped that to about $54 billion and asked for a $30 billion supplement on top of that, and Congress has approved about $15 billion of that $30 billion so far. So again, we're seeing sequestration caps coming off and a greater demand for weapon systems to meet the security threats. The Pentagon budget is expected to be about 3% to about 5% compound annual growth over the next 4 years. Next slide, please. On the global side, again, marked increases over the past years, 3.5% increase in global defense spending, primarily driven by increase in foreign military expenditures and therefore increase in number of foreign military sales by the U.S., again, to address rising global threats as well as terrorist threats. The foreign military sales from the U.S. is going to be another banner year this year, 2017. Over the last 5 years, we've seen an increase from over 118% from about $21 billion to about $46 billion. Next slide, please. Driven by the defense spending increases as well as the commercial aircraft increases, we're probably looking at a pace that's going to be above the $25 billion annually for the last 10 years, according to Price Waterhouse, in terms of mergers and acquisition activity. Again, defense increases and commercial increases are moving forward, thereby pushing more M&A activity. Next slide, please. The first half 2017, the U.S. looking at about $18 billion. That first half is over 2016 and 2017 by many percentages. Again, this is being expected to continue in 2018. It's primarily being driven again by the defense budget exceeding the sequestration caps, as well as commercial jet orders exceeding expectations. If we looked at the Paris Air Show in June, we're talking about twice, that's 50% over the expected increases from commercial aircraft orders that were placed that year. The Trump administration's focus on global government IT as well as security presents some upside for additional mergers and acquisitions. Next slide, please. Obviously, the most attractive place, if you haven't gotten it so far, is commercial aircraft. That's the place to be, primarily due to increased passenger demand globally, due to lower fuel costs primarily. Not only is Boeing and Airbus benefiting as a result of this, but everyone in the supply chain is benefiting from it as well. In terms of the overall transaction value, 70% of the transaction value in 2017, expected to even be higher in 2018, is for aircraft OEMs and part suppliers. Next slide, please. The types of deals we're looking at, primaries are acquiring large non-primes or large subsidiaries of the primaries. There's going to be an increased number of middle market activity as well. And you might even see large primes. This has been in the air for many years now, but large primes, as the sequestration caps come off and there's the increased security threats globally, the large primes providing the efficiencies to provide equipment quicker, and therefore looking at a merger between two of the large primes possibly. The current DoD policy is to not allow that to happen in order to maintain competitiveness as well as a consistent supply source for their equipment. But we're seeing this happen immediately, and it's fortuitous. It happened last week. It was the first large prime contractor offering, I think it was United Technologies, $23 billion acquisition of Rockwell International. And both Boeing and Airbus are looking at that with skepticism. Again, for those reasons, they don't want their supply chain, their parts being disrupted by merger of two primary contractors. Next slide, please. The increase in M&A and also the outlook generally globally for aerospace and defense have pressed intellectual property upward as well due to the improved economy. And these increases are expected to continue in 2017 as well as 2018 in the foreseeable future. Next slide, please. The major aerospace and defense manufacturers have over 60,000 patents or patent applications filed in the United States and over in Europe. 6 of the top 10 filers are in the A&D space itself. So if you think about it globally, we're talking about more than half of the companies in aerospace and defense are the main patent filers. Aerospace and defense application filings in the USPTO, the US system, is going to be approximately 2,000 this year. Next slide, please. Commercial OEMs, suppliers, defense prime contractors are looking to build their portfolios to make themselves more stable in upcoming times as well as down times. The startups are looking at improving their position in terms of capital contribution as well as improved acquisition opportunities. Doubling the number of patents a startup has increases the valuation of the startup by 25%, which equates to about a $12 million on average valuation of startup companies. So getting patents and patent applications filed, even provisional patent applications, is going to increase your valuation of your company. It also increases the capability for you to get more money, as well as increases the chances of your company surviving going through IPO. Key technologies, rather than focusing on just or selling off some of the research and development and information chain areas in order to focus on core technologies of their manufacturing for the aerospace, defense, and also commercial sector. The major aerospace and defense contractors are now looking at, both on the defense side and the commercial side, at moving into research and development heavily, including into the information chain that's frequented by the Silicon Valley area. Next slide, please. The technologies we're talking about that is driving the A&D landscape are the following. These are the big ones. Wearables in terms of sensors on your body, on uniforms for training activities, head-mounted displays for both the commercial side as well as military side, putting the information on the helmets themselves as opposed to heads-up displays or other aircraft equipment or instrumentation, and also smart glasses for the operator on the field, both on the, like for example, the Army going out with their smart glasses, providing the information right to their glasses. And drones and advanced robotics, I'll talk about that momentarily. That's the biggest one right now. Terahertz imaging for maintenance and equipment, searching its non-destructive sensing technologies that don't also hurt individuals that are around them, so that's very important. Smart sensors is very critical. It's going to increase lightweight materials, not only due to their weight, but also to their non-corrosive effects and their increase in robustness. Nano-coating technologies to, again, increase the durability of various products as well as their non-corrosive behaviors. And then the improvement of lithium batteries and microgrids. We really haven't seen much of an improvement in terms of lithium battery technology since about the early 1990s. This is drastic increases that they're looking at, and also applying microgrids so you can go off the normal system and operate independently. In terms of drones and advanced robotics, some of the biggest players in the drone area in terms of filing patent applications, the greatest increase out there in terms of filing patent applications is in drones and advanced robotics, primarily drones. The top 3 manufacturers are some of the top guys in the aerospace and defense. Boeing, Lockheed Martin, and Raytheon account for almost 1,670 new drone applications. There's over 4,600 unmanned aircraft systems patents or patent applications have been filed globally, or filed with the USPTO. And so that's an area that we're going to go into and we can help people out with. So thank you very much.
information. Question here. Yes.
Just wanted to know, I believe had a contract with Iran to sell them a bunch of airplanes. Does he know anything about that? That's been approved, or has the government told them can't do it?
So Boeing and Iran, a big deal. Is that on as far as you know?
Yeah, currently it's still on. It's going to be changing, though, obviously. I think that there's going to be an effort to rescind that contract. We'll put additional pressures on U.S. contractors in their current supply agreements. We're already seeing that pressure happening with the European nations who have already been providing it. You're going to see that increase happening as well. I think there's going to be a big pushback, so there might be some middle ground in terms of maintaining supply contracts while also increasing the pressure on Iran. But it currently is still on. Yes.
So the drone advances in drones, how does that impact commercial builds in the aerospace? How does that affect one another? Are they independent? You know, whatever happens on the drone side doesn't really affect commercial travel. You know, if you've got all these things flying around, how does that eventually integrate?
Yeah, we've got a very, very strong U.S. unmanned aircraft systems and robotics practice here. And we follow this very, very carefully. It is impacting how they operate. Their current system is essentially trying to integrate drones into the commercial airline rules and regulations. And the thinking now is to essentially separate those two out, have essentially zones where they can fly that will have no conflict with commercial aircraft. But ultimately, the plan will be to bring these drones to the air cargo and transportation of human beings. And they're trying to do that within the next 15 to 20 years. And that will happen, and that'll change the laws that apply to commercial aircraft. But they're trying to separate out drones while still trying to integrate them into the current rules by essentially deconflicting airspace and various technologies to avoid sense and avoid the other aircraft airborne.
Okay. Thank you, Tom. We're going to shift over to your partner there, David Clough, I believe it's pronounced. David is going to be talking about recent developments impacting pharma companies and medical device. So we're going to go shifting from the air into the medical field. David, thank you for sharing your information. We have about 20 minutes left, and so we've got two more presentations, David, and then Michael after that, and then we'll be wrapping up.
Okay. Well, the focus of what I'll be talking about is intellectual property and the recent legal developments that affect a variety of areas. We'll be talking about venue for ANDA and ABLA cases, diagnostics and patentable subject matter after mail, trends in IPRs, biosimilar review, and if I'm running out of time, I'll skip the Amgen versus Sandoz case. To understand the peculiar issues here with respect to venue for ANDA and ABLA litigation. ANDA litigation is it's abbreviated new drug application, which allows a generics company to use some of the data that the brand company generated in their FDA submission to get an abbreviated review. And the same thing is true for ABLA. ABLA is a very recent, it's a biological license application. It's a fairly recent phenomenon. With that aside, in T.C. Heartland versus Kraft Food, the Supreme Court venue case overturned the federal holding, stating that their 1957 Forco case was good law, reaffirming its position that 28 U.S.C. 1400 is a whole sole provision controlling venue. What the Federal Circuit had decided was that for all venue purposes, venue is proper if the defendant is subject to the court's personal jurisdiction. As happens in virtually every Supreme Court, the Supreme Court overruled the Federal Circuit. That's a virtual certainty whenever the Supreme Court takes a Federal Circuit case. The Supreme Court said the venue was proper if the court sits in the defendant's state of incorporation. That one's easy. 2, if the court sits in a district where A, the defendant has committed acts of infringement and where the defendant has a regular and established place of business. The first prong is self-evident. The second is not. 2A stated that it's proper where the defendant has committed acts of infringement. Well, in fact, ANDA and ABLA applicants have not yet had a commercial sale, so they don't have an actual infringement, except that there is an artificial process where when they file their applications, the brand drug, or in the case of ABLA, the RPS holder, has to sue within 180 days of a certain notice. Traditionally, the situs of infringement, the focus should be on where the ANDA or ABLA filer is likely to target sales or marketing, which may be informed by past activities. Some courts have held that the filing of an ANDA confirms the future intent to market the generic product throughout the United States, conferring very broad jurisdiction. Now, we already know what a regular and established place of business means: a permanent and continuous presence in the district, not necessarily a physical presence. At the end of the day, and by the way, this case is very new, so nothing's happened after that. At the end of the day, speculation is that the infringement arm of this law will be fulfilled by marketing efforts in the district, web access in that district, registrations to do business in that district, and the establishment of contracts with wholesale and distributors in that district. We'll now move on to patentable subject matter, which has caused a great deal of heartburn in the diagnostics industry. Diagnostic companies typically measure things that are naturally happening in the human body, and the courts would call this their natural laws. In Mayo versus Prometheus a number of years ago, the court held that simply measuring such things and making a mental decision as to what to do was not patentable, because they're simply measuring a natural law. Obviously, this has thrown into question the validity of literally thousands of diagnostic patents, and you can only imagine what all of these relatively small companies are doing these days. They're actually, many of them are closing down. However clever people that patent lawyers are, a lot of work has been done as to how to confer patentability on these things. There are several things you can do. You can detect a novel molecule. It may be naturally occurring. And as long as a molecule is not well understood, this step confers patentability. You can use a novel diagnostic reagent to measure one of these natural phenomena. And in fact, we had a client that did that. They were looking at a structure that contributed to metastases of cancer, and the patent office came back and said, well, you're just measuring something that's naturally occurring. But the fact of the matter is that we had novel detection reagents, which is sufficient to confer patentability. This one seems kind of crazy to me, but it works. Add another treatment step after the diagnostic step in the same claim. Say, we detect this natural phenomenon, but then we treat with this. That has been shown to be patentable. And the other thing that you try to do, and this is the case of biomarkers, test for a novel combination of biomarkers. I'll now move on to, again, a relatively new phenomenon in the patent world, and they're called inter-parties reviews. Inter-parties reviews are a means by which a third party can challenge the validity of a patent in a fairly expedited proceeding, which lasts about a year. It's really a mini litigation. It's supposed to take a year, but it's now taking about 14 months. Typically, IPRs are initiated by somebody that got sued, and they want to try to invalidate the patent that they're being sued under. I'll just give you a very brief summary of the statistics as to what's going on in the life sciences world, which is not anywhere near the size of the tech world. In life sciences, 22, one step short, the institution rate is very high. They aren't instituted automatically. You have to go to the patent office and make a case that there's a substantial question of patentability. 75% of the life sciences patents institutions is probably 25% above the rest of the industry. All claims were patentable in 39% of the cases. All claims were unpatentable in 59% of the cases, and some unpatentable in 2% of the cases. And it turns out that there has been a very high settlement rate. Just with respect to medical devices, the decisions regarding institution, out of the 315 cases filed, 222 have been instituted. Pending institution decisions, 63 instituted and subsequently settled, 51 instituted and pending final decision, 45, and not instituted, 73. I think I'm going to skip this next part. I'm just going through a very recent case, and I'll be done in a minute. This and ANDA biological litigation, in particular the biological litigation, most of the litigation going on right now involves somebody trying to interpret the rules, which seem on their face to be very straightforward. What has happened here, the rules require that the applicant has to provide the reference product holder, the brand, with the details of its application within 20 days of receiving notice of FDA review. I'm going to skip the facts of this case. Sandoz didn't do it. Amgen sued, and the DC Circuit held the failure to disclose does not authorize the product owner damages. To get to what the Supreme Court said, is that commercial notice, which is telling them when it's going to be marketed and disclosure of the application, is not enforceable by an injunction compelling disclosure of the biosimilar application. What their suggestion is that there may be a state law remedy. And everybody was beginning to think what kind of state law remedy would be. Well, Amgen explained that about a month ago when they sued Sandoz in California under the California statute for unfair competition. We'll see how that turns out.
Thank you very much, David. Appreciate that information. And so for those of you involved with intellectual property in those areas, please contact David. We're going to now wrap up with Michael Rosenthal in the same office, and then I'm going to come back to Melissa just for a few seconds at the end, because we want to see your beautiful face and also hear from you in terms of, for those of you who are watching around the world, maybe an overview of kind of how do you approach Polsinelli. Does it come from you or go individually, and how does that work? The next conversation and our last conversation today with Michael, you're going to be talking about global mergers and acquisitions. Beautiful topic for our global crowd. Thank you, Michael.
Great. And I'm going to try to keep it at a relatively high level, particularly since we're wrapping up and, we're a couple of minutes behind, so I'll try to keep it high level, but also informative. Global M&A and cross-border M&A continues to be a significant driver of mergers and acquisitions activity throughout the world, and particularly in the United States. With the increasing globalization of the economy, there are more opportunities to create synergies, as well as more investment opportunities that cross borders. And so we've seen a real pickup in that kind of activity. That had started probably going back before the financial crisis in 2008, and it hit a very high level where virtually 25% of M&A was cross-border. That has dropped after the financial crisis, probably because as money got tighter, it was harder to do deals that sort of crossed both physical and cultural borders and engendered a sort of different kind of risk in integration and operation. And it started to pick up again in the last couple of years. Another big driver in that is really a new player in the global M&A world, which is the Chinese. If you look at sort of statistics going back to 2010, the Chinese are sort of virtually non-existent in the M&A world. They're doing very few deals and represent a very small segment of the overall M&A deal flow. I mean, if you look back at 2005, 2006, and 2007, the total volumes are barely, $2 or $3 billion across all deal flow. What you see is starting in 14, but particularly in 15, that kicks up a significant amount, hitting almost $150 billion in 2016. So you can see the Chinese have become a very major player. So how does that impact M&A for a company in the United States or a global company outside of China? There are a bunch of different things you need to think about, and some of it has been impacted and has sort of been reflected in M&A activity this year. So the Chinese M&A market is regulated in a much more stringent manner than the M&A markets in most other countries. This is whether the company is a public company, so traded on the NEEP or another exchange, or alternatively a private company. Because of the regulations by the SAFE, which is the state-administered foreign exchange council of China, any kind of migration of yuan outside of China requires SAFE approval. So it's effectively every deal is going to require a level of SAFE approval. What happened in 2015 and 2016 is the Chinese began to see a lot of currency moving out of the Chinese market into the international market. And that was done, A, for strategic reasons, but also to a certain extent from a currency play perspective. The Chinese yuan was decreasing in value, and so a lot of Chinese investors were trying to move their currency offshore. And so they were looking for relatively safe type of investments to move it offshore, and or investments that would be a little bit more liquid. And so what you saw is investments in real estate and hospitality and sports teams and things like that, which the Chinese government looked at and said, well, how is this helping our economy? How is this helping us grow? And in the same respect, we're watching an outflow of currency from our country abroad. And so dramatically in late November of last year, they in essence enacted brand new legislation that put very, very tight controls and very strict regulatory authority on the ability to essentially use outbound currency from China. The result was a very drastic, probably a 45% drop in M&A activity for outbound Chinese M&A activity during the first half of 2017. It didn't stop it entirely, but what it did is create further concerns. And I can tell sort of a story of a deal I worked on where we got lucky. We've been working on a deal to acquire, we were working with a Chinese company to acquire a U.S. company, and the deal had been worked on from February, and we finally signed it in September. We got all of the regulatory authority in place, and everything was done in November, and we were going to close in early December. The money moved from China to the United States shortly before Thanksgiving. Right before Thanksgiving, these new regulations were passed. Had our money not moved into the United States before those regulations were passed, it would have killed the deal. Because even deals that had been previously approved had to go back through this much more rigorous approval. And so we were at the end point of our drop dead date, and we would have hit the drop dead date, and there probably would have been, the deal would have died, and there would have been a reverse breakup fee that we would have had to pay. So there's a real concern there. China sort of realized that, and very recently, within the last month, has passed new regulations, which are designed to reopen up the pipeline for preferred type of investments. And those are things like technology and healthcare and infrastructure. And so those kind of investments will still be subject to safe approval, but the thought is that it'll be done on a much more expedited basis. The so-called bad investments, sports teams, real estate, leisure, and things like that are likely to continue to be much more controlled because there's a fear that those are really places where there's potential for currency manipulation. So that's what we're seeing in the market. In the U.S. side, there's a counter to this and a concern that the Chinese have about investing in the United States. Our CFIUS regime, and I think that may have been touched on a little bit earlier, which essentially regulates the ability to do transactions which in some way implicate national security, have now raised concerns, particularly with some of the rhetoric of the Trump administration, that CFIUS could be used as a tool to, in essence, interfere with Chinese M&A, inbound M&A to the United States. And that regime has sort of chilled the Chinese to a certain extent, and so they're looking at Israel, Asia Pacific as other places that may be more hospitable for them to do transactions rather than the United States, for a fear that they're going to have either get held up in the CFIUS process or alternatively have CFIUS applied in contexts where you wouldn't traditionally think of national security. The result is when you do a U.S.-Chinese transaction, I made mention of reverse break fees, they've become much more frequent because a U.S. target who has gone through an auction process with a bidder and come out with a Chinese bidder wants to protect themselves against safe and other Chinese regulatory risks as well as the CFIUS risk. And so they will require frequently the posting of a bond or an escrow and effectively use that as a reverse breakup fee. So with that in mind, why do you want a Chinese buyer at your auction? Well, they drive up the prices is the general view. The Chinese market, because of the size and current status of their overall economy, whether it be technology, healthcare, or otherwise, they're an enormous economy that is growing, as opposed to the U.S. economy, which is growing, but at a much more limited rate, because we're a mature economy. Their economy is not mature, it is maturing. So when people look at valuation and decide how much a company is worth, they look at the potential for that maturing market. The Chinese value companies based upon that maturation process. And so if you look at the values that are prevalent on the Chinese exchanges, they tend to be trading at higher multiples than the U.S. And so when a Chinese company comes into an auction, they're looking at those multiples, thinking about it from that multiple perspective, whereas a U.S. buyer is looking at U.S. multiples. The other reason that they view it that way is because they see an opportunity, a strategic opportunity to grow these companies within China. So, for example, in the pharma space, what you'll see very frequently is companies in China looking for a product. The Chinese market is very difficult to navigate for non-Chinese companies. And so you need a partner or you need a sponsor within China. And so they've taken advantage of that through both licensing transactions, but also M&A transactions, that they can grow their company. They're doing their own R&D there, but they see opportunities from what might otherwise be viewed as sleepy companies within the U.S. or global markets that they have 1 billion customers for, and they've just scratched the surface. So they're willing to pay a little bit more. It's why bankers, when possible, will always try to get a Chinese company to the auction. The real answer is you want them in the auction to drive up pricing. You probably would prefer them not to win because of all the difficulties of deal execution. But sometimes you can't have your cake and eat it too, and so they win, and so you have to be prepared for a process that's not quite predictable, not quite time sensitive. So we're used to a process that has hard timelines. You think of Hart-Scott-Rodino filings, there's a very tight dance and process. And I can tell you within 30 days, you're probably going to know whether you have a problem or not, and you're probably going to be clear. With the Chinese, it's not timelined quite that way. You're kind of taking a little bit of a guess. Now, there are Chinese lawyers who've been through the process who can help you handicap, but there's never the same kind of degree of predictability. And that's something that I think their government with the new regime with the new legislation is trying to focus on, because they understand the potential for M&A to drive stronger companies within the Chinese market. So that's kind of a summary of some of the highlights of what's been going on with a real focus on China. As I mentioned, it's something that we've done here a bunch at Polsinelli, and would be glad to talk more with you about, both from an M&A perspective, licensing perspective, and otherwise. So thanks much.
Thank you, Michael. We'll take the questions offline so we can wrap up. The standing ovation in Chicago, it sounds like. Melissa, come up, and before Melissa says our final words, I wanted to thank Michael, you, David, and Tom there in Chicago, and Tony, who is so active in the international world there in Chicago with Polsinelli. Richard in Denver, thank you very much. Yarno in New York City. Greg in Washington, D.C., Chris in Wilmington, and then Mike and Melissa here in Phoenix, Arizona. We've been across the U.S. and we've been across the world. So, the world is a big place, and we tried to accomplish a lot today, and really appreciate everybody's patience, both in the audience and also all of you speakers with the technology and getting through. We can't possibly cover everything. So that's why we talk. That's why the Global Chamber is here. That's why we're everywhere, because what's happening today changes tomorrow, and it's going to change next year. And for companies that want to be successful, we're going to be there. We're growing in 525 cities around the world. So thank you, those of you who are members. If you're not a member yet, why not? We're going to be where you want to be, and we really thank Polsinelli for supporting us and supporting some really great talented speakers, as you've seen here today. Thank you also for the IT teams and also the administrative teams at each location for Polsinelli today for making this happen. Three things that are coming up on a global level for Global Chamber. Tuesdays in October are going to be busy. October 10th on cultural events like this. We're going to be talking with experts about how to handle cross-cultural issues. And then on the 17th, it's new opportunities in Asia. So especially with Michael's conversation about what's happening in China, and any of you who are doing business in Asia and Indonesia and some of the amazing things that are happening there. We talk about trade and we talk about restrictions on trade, but when you see what's happening in the world, it's kind of a silly conversation because it's happening, and I know all of you who are participating today want to participate in it more effectively and more productively. And then finally, on the 24th of October, we have new opportunities in Europe. Europe is not dead. You know, it's still around, and post or pre-Brexit, you know, there's still a lot of opportunities there, as there are in Africa. So thank all of you for attending. Melissa, thank you for your presentation today. Thank you for hosting this spectacular array of knowledge. Could you say a few parting words and maybe to our audience around the world, you know, how do they tap in?
Okay, terrific. Thank you so much, Doug. And I got to tell you, we are so thankful and so happy that we're members of Global Chamber, and that we're participants. We support them. It's a great organization. Our offices around the country are also members of Global Chamber in those local cities as well. So I would encourage you to seek out Global Chamber if you're not a member already. It's a great way to stay tuned. It's a great way to network. It's just a fantastic way to get in touch with the world. I think Mike Patterson said at the very beginning, Polsinelli is an AmLaw 100 law firm. We've got over 800, upwards of 800 attorneys around the country. I've been here for 3 years, and I've got to say that every day that I come in, I learn more. I'm impressed by the depth of knowledge and the experience these 800 plus attorneys have, not only from industry, but also on the legal side as well. It's both very operational and legal. So what you've seen today is really just a cross-section, a small cross-section of the different practice areas and the talent that we have here at Polsinelli. So I would urge you to reach out to any of the speakers that you saw today and that you heard today. They'd be happy to assist you or definitely get you in touch with the right person depending upon the issue that you have. In terms of international business, international trade in particular, especially anything having to do with Mexico and Latin America, I would say definitely reach out to Mike Patterson directly. He and I work very closely together, but he is really our Latin America guru on all things international business. Please visit our website, www.polsinelli.com. You can find out specifically about all the different services that we offer, as well as all the professionals, and we have a lot of blogs, and we would invite you to check out our blogs, follow them. We try to keep all of our clients updated on legislative and regulatory and really the economic and industry developments as they happen. So thank you very much for your time today, and Doug, as usual, thank you so much for the opportunity.
And final thanks to Cesar of Global Chamber, because without Cesar working with Cindy and others, this wouldn't have happened. Thank you all for watching. Thank you, Melissa, and thank you, everyone.
Thanks.
Thank you.
All right, thanks, Doug.